the WTO, and maybe that might also spark eventually discussions in China about whether that is something we should aim at, more neutrality and objectivity in the adjudication of rights. That is it. Thank you.
Okay, thank you very much. Well, thank you very much. We now have some time for questions and discussion. Because the panel is quite large, it would be helpful if your question is focused at a particular speaker, perhaps you could indicate that in your question. But can I also say, please, let's have questions, not speeches. I'm conscious that some of you are probably, during your time here, practicing for when you ascend to some important position within the CPC, and we've already talked about Li Keqiang, and I mean, no doubt in this room there are future Lees who some of us may live to see. I'm sure Jan will, but maybe not all of us. Okay, so who would like to kick it off? Atta.
Yeah, I'd like to.
For this purpose, Professor Hussein is being deemed a student.
Yeah, I'd like panel to comment on, probably Professor He, on extrajudicial discipline and penalties. For example, Laogai, or alternatively other things, the party disciplinary procedure Shuangui, and finally also the gray area of law, like the housing which is sold under the name of little property rights, which is very common in China.
Thank you. I think that's a comment rather than a question. So I think we should, if you don't mind, Atta, with no offence, I think we should just move on to see if we have a question. I mean, because they may want to bring it in.
OK， 因为我对3位中国的学者提问，所以我用中文讲啊。我非常同意3位提出的观点。我也个人认为，中国未来的这个民主化的进程是离不开司法改革、司法独立的。那么我们也看到，就是说，这个不搞司法改革，没法使得中国的社会变得更加的可持续、更加的健康。但是，这个怎么破？就是说，怎么打动这边司法改革？刚刚提到司法该独立，是司法地方化是个事实，但是现在。3位能否看到什么样的力量能够迫使领导层意识到要改这样的一个 driving force 有哪些？因为我们都知道，如果上层不动，这是没法改的，对不对？司法独立改革，而司法不改，所谓的民主化进程是没法推进的。那么此时此刻，就是说上层有没有感到一种特别需要推动的这种动力？来自自下而上的也好，或者上层党内的这种权力斗争也好，3位有没有看到哪些现象？谢谢。
好的，非常感谢我来回答。加藤先生，这个大家刚才也赞叹说加藤先生的中文也这么好，因为有人说你的英文也特别好，当然你的日文也非常好。因为我跟加藤先生也认识很长时间，所以我也觉得特别高兴能够回答他这样的问题。我想现在的情况是，其实中国共产党向来不是一个完全一致的党，最高领导层之间也有许多的相互之间的分歧矛盾。比方说我们有一些个别的接触某些比方退下去来的一些人。或者说，影响到现在在位的在台上的一些人，他们的思想观念非常的开放，而且有一些人坚定的主张说中国必须走司法独立的道路。但现在我觉得司法独立，我们切不说，不用说需要的一种意识形态性的变革。在我看来，社会主义这样的一种学说。跟司法独立之间存在着一个内在的冲突或者紧张，它几乎是不能包容这个司法独立，因为你司法独立跟党的领导之间，它就是没有办法协调的一个问题。 但是我们不说这个，我们只是说是司法独立是不是走到一定程度的时候，那么就会让党来意识到这是很危险的一个做法。也就是说，那句老话说，不改革会亡党，不改革会亡国。到底党重要还是国家重要，就变成考量的一个非常重要的因素。所以我想，现在可能有一些因素非常明显，比方说，现在越来越多的证据表明，中国的经济的存在着非常大的一个灾难性的东西，来自于司法不独立，来自于司法的地方，比方说，陈有希律师代理重庆的案件，有许多的企业家。就是说，在地方的一个官员看来，他完全可以把私人的财产、一个企业家的财产完全没收，说你是黑社会，你就是黑社会，这是非常可怕的一件事情。所以最近的企业家们，越来越多的人说，我到国外去，我到加拿大去，我到澳大利亚去，移民的倾向非常严重，这对我们的经济发展是一个很大的威胁。所以这个，如果说中国共产党非常关注经济的长久的发展繁荣，那么这个问题可能是一个很大的一个动力，或者说一个推动的力量。另外再就是民众在观念。我觉得这改革开放可能30多年，法律改革30多年，对民众判断什么是一个良好的政府，变化非常大。以前人们只是想说有伟大的领袖就好，有党就好，但现在大家越来越多的人觉得没有独立的司法是不可能好的，这样的一种民众观念的改变会非常大的一个压力。最后，我想这个 Yax， 我的老朋友他提到的这样的一个外部环境，我们在座的许多的同学，可能你们的家庭背景有许多，可能你们的父母亲也是政府的官员，你们越来越多的可以传递信息，告诉他们说什么是一个好的一个政府。然后如果没有一个国家没有独立的司法，这个国家的领导人其实是没有尊严的，而且他们也很危险。你想，他们在位的时候看觉得很风光，他们不受司法的管理，控制，但是他们一旦出现问题的时候，就像现在的薄熙来。他现在感觉到没有独立的律师来为他辩护，没有一个独立的法院，这是多么恐怖的事情！所以谢谢。
I think. Okay. I want, because I think this is really the question that's just been asked is a fairly central question for our purposes, and I'd like to give other people on the panel the opportunity to comment. But before I do, I think on this question of independence, we need to be clear that there are a number of different components to this issue. In a country like this, we would include in the general question the independence of lawyers. We would be looking at how the legal profession is organized. We would look at how judges are recruited, how judges come to be judges, and what the relationship between judges, individuals becoming judges, and lawyers is. And in European systems, this is organized in a different way. This question of independence isn't a simple one. And I think in the Chinese context, as I said at the beginning, the other issue that we always seem to come back to, but perhaps we need to think through a bit more, is the relationship between lawyers, judges, and the CPC. In other words, it's not just as it has been in Western tradition, a question of the relationship between government and courts. Because clearly in China the party is a kind of strand that runs. You can separate institutions, but the party is like this thing that runs through and maybe holds them together. Anyway, would other members of the panel like to comment on this really very central question that we've been asked?
Briefly, though. Very briefly. It's an important question, just to echo what our chair just said. The debate in China is rich with the question about the differences between judge independence, court independence, and judicial independence, or adjudication independence, which are very different. And you do see, I think, a quite robust debate that says sometimes lack of judge or lack of court independence is important for checking corruption and incompetence. And so it's a very murky area. But in response to Kato-san's question in part, one of the best hopes for building some degree of judicial independence, again, setting aside the difficulty, is that it may come to seem more and more better than the alternatives. And this is partly Hu Weifang's comment about losing the party or losing the country. If you don't find some other way of providing redress, you may wind up with more pressure for political change or more instability. If you don't find some way of channeling those kinds of concerns. And I think that there is a story to be told about the embrace of law in a more than purely rhetorical way by the party state in China that says this does at least two things beyond the obvious one of promoting a market economy. It checks it can at its best, checks some of the worst economic predatory behavior by state and state-linked actors, and it can provide a steam valve and a feedback mechanism and an input mechanism that is less dangerous than people in the streets or people demanding the right to vote. So in that sense, and one of my old mentors pushed this very much, law can be a very conservative thing. And I think there's some appreciation for that.
Thanks. Would you like to?
好的。刚才莫菲教授和戴杰教授实际上对中国通对中国的司法情况比我们中国的学者还了解。中国有一句古诗叫“云横秦岭家何在，雪涌蓝关马不前”。
这个就不好翻了。
在中国的环境里面，现在确实司法改革举步维艰，大家都比较悲观。政党的关系是绕不过去的。当然，政党关系我们在 LSE 再这样讨论，到中国国内去就可能就不能够完全放开讨论。所以贺教授已经讲了，我这不再重复。但我想讲几点：第一，司法独立不是西方法学思想。司法独立写在中国的宪法里面，中国的宪法明确规定了法院的审判权独立，还有中国还有很怪的一个学苏联的，就是检察权独立，实际上就是一个法院独立。所以说到底就是一个思想观念的问题，就是某一个政治家用我们现有的宪法，他照样可以搞司法独立。所谓的法院独立，真正的就是合议庭独立，合议庭独立最后就是法官独立，法官独立就是我们所追求的司法独立。第二点，现在中国司法独立的，刚才加藤讲到的，有没有可能性？就中国原来的我们的10年，采取的是高压维稳，这条路已经走到了尽头，越压越不稳。所以我们要高层要思考一个新的管理办法，所以它也有可能走向一个让法院稍微的有点权利，把政党的权利、政府的权利慢慢的转移向一个中立的法院、超脱的法院、公正的法院。刚才贺教授讲到了，像我们的一些官员自己出事，他就希望法院是公正的、公开的、独立的，所以他有这个需求。第三个呢，就是这互联网。是我们，对吧？现在这个民智已开，中国的300多部法律，老百姓都知道。现在的所有老百姓拿起法律武器到法庭上去，这种动力比较强大，所以官方再要想控制也很难控制。所以中国将来的还有一个400多万的法学院毕业的学生，好多在公检法里面都院长、庭长、公安局长了。所以中国现在社会科学、法学学科的人才都在起来。所以，无论是民智已开，还是我们的国际环境，以及网络的环境，以及我们的队伍结构，司法独立慢慢的是会来到的，但是这个路还很远，不会很快。谢谢。
Thank you. Another question or comment. We'll go there.
你好，各位谈了很多司法方面的问题，我想问一下， 立法的细化和明确化能否帮助我们解决现今司法方面存在的问题？因为我个人觉得，在现今政治制度下，立法方面的进步要比司法改革容易一些。就个人的愚见，不知道对不对？
这个我 OK， 这个我抢一下话头，我来回答。立法的问题，中国现在通过20多年的立法，现在全国人大和常委会通过的法律是300多部。 国务院和地方一级人大，就省一级人大通过的行政法规、地方法规2万多部，所以中国已经完成了有法可依的阶段。现在就是怎么样有法必依，严格的执法，就有法必依，违法必究。那么另一方面，法律多了是不是都是好事？不见得。现在我们在处理刑事辩护当中，发现中国的国有企业和民营企业。 要把一个企业家整到牢里去非常方便，我们立法细化了以后，法网非常严密。我们光是市场经济秩序方面的犯罪罪名是112个，你不是侵占罪，就是偷税罪；不是偷税罪，就是营业诈。